Does the ministerial exception to the First Amendment mean that a priest cannot sue the Catholic Church, his employer, for a hostile work environment claim? To find out, you have to read Ibhawa versus New York State Division of Human Rights, but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Ibhawa versus New York State Division of Human Rights. The citation for this case is 2024 New York Slip Opinion 05872, published by the New York Court of Appeals on November 26 of 2024. The issue in this case is whether the ministerial exception that derives from the First Amendment means that a priest cannot sue the church for a hostile work environment, and whether that's ministerial exception applies to jurisdictionally deprive a New York State court from adjudicating a hostile work environment claim. To understand and appreciate the context of this case, the helpful background to know is that the First Amendment to the United States Constitution protects the right to freedom of religion, amongst other things, freedom of the press, freedom of speech. But a ministerial exception has developed through case law that means that it protects the right of religious institutions to decide for themselves, free of governmental intrusion, matter of church government, as well as those of faith and doctrine. And it supplies an affirmative defense to claims that are brought under laws governing employment relationships between religious institutions and key employees. That's the ministerial exception. There are famous cases from the United States Supreme Court about this. The Tabor case, amongst others, is the most important recent one. It's called the Hosanna Tabor case and Our Lady of Guadalupe. Those involved unlawful termination claims against religious institutions, not hostile work claims. And there was an open question as to whether a hostile work environment claim could also involve that ministerial exception to the First Amendment. So what are the facts of this case? The facts are that Father Ibhawa is a Black Nigerian Catholic priest who in 2016 started working at the Catholic Diocese of Buffalo as the parish administrator of the Blessed Trinity Church in Buffalo, New York. In 2019, so 3 years later, Father Ibhawa was reappointed for an additional 3-year term. But in September of 2020, the diocese prematurely terminated his employment. 2 months later, Father Ibhawa filed an employment complaint with the Division of Human Rights, which is New York State's administrative agency that investigates employment discrimination claims, including racial discrimination or other kinds of discrimination. In this particular case, Father Ibhawa claimed that the Catholic Diocese, his employer, had engaged in discriminatory employment practices, including using racial slurs against him. A parishioner had made xenophobic remarks to him. He alleged that that the Catholic Church officials declined to investigate the complaints he made to them about the xenophobia and the racism. That the diocese officials declined to actually investigate it. They made highly insulting and offensive remarks to him. The diocese officials told him to buy a plane ticket back to Nigeria, and that they threatened that the bishop could remove his priestly powers, his status as a priest. And then they terminated him. And they ultimately replaced him with a white priest. So he claims that they violated his rights, his civil rights and his human rights under the New York State human rights law. And in response, the diocese, in response to that claim made to the DHR, to the Division of Human Rights, they raised 3 affirmative defenses, including the ministerial exception. They said, you're New York State and we're a church, and you don't have the right to tell us how to run our business. And so they said it should be dismissed because a determination of who will lead a congregation and teach its faith falls within the statutory exception of the ministerial exception. DHR, the Division of Human Rights, then issued an answer to the complaint dismissing the action. They dismissed it and they said that it falls under the ministerial exception because it's undisputed that Father Ibhawa is a minister, is a priest, and the other side is the church. So they said that DHR cannot proceed because it lacks jurisdiction over the matter. So they dismissed it for lack of jurisdiction. Father Ibhawa appealed this decision by DHR. The Supreme Court reversed in part and affirmed in part. The Appellate Division reversed the Supreme Court and said they weren't giving adequate deference to the Division of Human Resources. And it goes to the Court of Appeals. And they say the appellate division is wrong, and they have to send it back to DHR for a full, fair adjudication. Why? They say that, first of all, they say with respect to the standard of review, they say DHR is an administrative agency. And so as an administrative agency, the court has to consider whether it was either affected by an error of law, was their decision arbitrary and capricious, or was it an abuse of discretion? And here they say the legal question before them is, does the ministerial exception apply to a hostile work environment claim, or is it only applied to termination claims? That's a legal question, and so they don't have to give any deference to what DHR thinks. And here DHR committed an error of law. Why? Because even if it applies, the ministerial exception is an affirmative defense, not a jurisdictional defect. What's the difference? A jurisdictional defect, jurisdiction is the power of a court to adjudicate a matter, the power of an agency to adjudicate a subject matter. It's not fact dependent, it's concept, it's subject matter dependent. And the subject matter in this case is a hostile work environment. So DHR has the jurisdiction to adjudicate hostile work environment claims. That's different than an affirmative defense, which is a question of who should win in the actual dispute on the merits. An affirmative defense means that one side should win if it's pled and proved that the affirmative defense applies, then that side can win based upon the affirmative defense. But that's different than jurisdiction. So in this case, the Court of Appeals says ministerial exception is a affirmative defense that can be raised, but it's not jurisdictional in nature, and therefore it's reversed. They send it back to DHR, and they say, do the work, consider the ministerial exception if you want, but it can't be dismissed on a jurisdictional basis for the ministerial exception. That's not how that works. And that's the case of Ibhawa versus New York State Division of Human Rights. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.